Welcome to The Explainer. Today, we're digging into a truly massive, glaring data point that recently popped up in federal procurement records. We're looking at a brand new project called Eyes on ICE Investigates the $150 million BURKE Law Group Anomaly, and you can actually find the full breakdown over at www.eyesonice.net. So what we're doing today is unpacking the hard data behind a stunning 95 out of 100 statistical anomaly score, which was triggered by just one single federal contract award. Look, when an algorithm scans tens of billions of dollars in federal spending and spits out a near-perfect anomaly score, it absolutely demands our attention. We're going to forensically break down exactly why this specific contract set off literally every statistical alarm bell in the system.
Okay, let's dive right into this. Here is our roadmap for today. Part 1, the $150 million anomaly. Part 2, unpacking the mismatch math. Part 3, a severe expertise gap. Part 4, replacing the legacy network. Part 5, the political appointee connection. And finally, Part 6, nationwide subcontracting risks.
Section 1, the $150 million anomaly. We are breaking down Health and Human Services Federal Register Notice 2026-16081, specifically 91 FR 5848.
Now just think about this number for a second. $150 million. This is the maximum total dollar value for a one-year period of performance, kicking off in August 2026. Keep in mind, this isn't some long-term, decade-spanning defense contract. We are talking about up to $150 million of your taxpayer funding compressed into a highly concentrated 12-month window. This sheer massive scale is the financial hook that initially flagged this entire data set for review.
And here is a totally crucial part of the puzzle. This staggering amount of capital was awarded via a single-source cooperative agreement. So what does that actually mean in federal procurement speak? It means there was zero standard competitive solicitation. The government did not put this out for a broad, open bid where multiple firms could compete to show who could offer the best value or the best capability. Nope, it went directly to a single vendor.
So because of that massive size and the total lack of competition, among a few other factors, the Federal Contract Anomaly Detection Report assigned this award a 95 out of 100 anomaly score. It is literally the highest flagged entity in the entire 90-day look-back window. Now, it is incredibly important for us to state clearly, as the official disclaimer notes, that an anomaly flag is not proof of corruption or wrongdoing, right? Legitimate operational or legal justifications might totally exist. Instead, you need to think of this as a severe statistical red flag. It's basically an algorithmic signal shouting to investigators, hey, the math and the metadata here are highly unusual and you really need to look closer.
Section 2, unpacking the mismatch math, boutique firm size versus a massive federal award.
The logistical reality here is just fascinating. You have a maximum contract value of up to $150 million, right? But who is actually executing this? According to the data, the vendor, BURKE Law Group out of Houston, Texas, has approximately 26 employees spread across 8 offices. And drilling down even further, they list just 5 named attorneys. That is a ratio of roughly $5.8 million of federal responsibility per single employee at the firm. And yes, that includes the administrative staff. If you isolate that math strictly to the legal practitioners, the attorneys, it equals an astonishing $30 million per named attorney. Consider what it actually takes for a boutique firm structure to manage that sheer volume of capital in a single year. It is an acute logistical gap. I mean, it's a huge disconnect, and it's the very first major red flag this system identified. How does a firm of this compact size suddenly absorb and deploy a 9-figure federal mandate?
Section 3, a severe expertise gap, examining the firm's documented legal practice areas.
There is a stark, unavoidable contrast in expertise here. BURKE Law Group's actual, documented primary practice areas are in energy law, environmental law, white-collar defense, and commercial litigation. However, this contract requires complex immigration defense for unaccompanied alien children before the Executive Office for Immigration Review, the EOIR, and U.S. Citizenship and Immigration Services. 0 of their 5 publicly profiled attorneys have documented specializations in immigration law. You literally have a firm steeped in energy regulation abruptly tasked with executing highly specialized immigration defense for minors.
Section 4, replacing the legacy network, from 100 specialized organizations to a single firm.
This represents a radical shift in federal strategy.
Historically, this legal representation was handled by a decentralized legacy network of approximately 100 different specialized legal aid organizations, nonprofits, and advocacy groups with deep, pre-existing immigration expertise. The new reality consolidates all of that fragmented funding and control under a single 26-employee boutique firm. It is a massive structural overhaul, replacing deeply entrenched specialization with extreme top-down consolidation.
Section 5. The Political Appointee Connection. Co-founder Marcella Burke's documented history.
So these data points are a matter of public record. Co-founder Marcella Burke served as Deputy General Counsel for the EPA from 2017 to 2018 and as Deputy Solicitor for Energy and Natural Resources at the Department of the Interior from 2018 to 2020. More recently, in 2023, she was actually appointed to the Texas School Land Board by Governor Greg Abbott. Additionally, the firm's co-founder Jeffrey Hall was recently confirmed to a position at the EPA. Now, to be incredibly clear, we are absolutely not alleging corruption or wrongdoing here. We are strictly objectively explaining the documented political history that the federal tracking algorithm identified when it was trying to make sense of why a small energy law firm received a massive unbid immigration contract.
Section 6. Nationwide Subcontracting Risks. The logistical reality of a massive single-source mandate.
Logistically, this unfolds in 4 necessary steps. Step 1. The boutique firm receives the $150 million mandate. Step 2. Basic logistics dictate they just lack the internal manpower to directly execute thousands of cases nationwide, right? Which leads to Step 3. By necessity, the firm must act as a massive pass-through entity, hiring others to actually do the work. And finally, Step 4. This creates vast subcontracting networks, established entirely outside the purview of direct federal competitive bidding.
Remember, this whole chain reaction started with a 15-point algorithmic red flag because the primary award totally bypassed standard competitive bidding. The Federal Register notice invoked a general cooperative agreement exception, providing a statement of need, but they completely bypassed the traditional rigorous open market vetting process that usually governs 9-figure government spending.
And that brings us to our final thought for this explainer. You have up to $150 million given to a boutique firm with no documented immigration expertise, bypassing standard competition, replacing 100 specialized organizations, which mathematically forces the creation of a massive, unbid subcontracting web. So, without traditional competitive oversight, who ultimately monitors how your taxpayer dollars flow through these obscure layers of subcontracts? It's a severe structural anomaly that absolutely demands rigorous accountability. And we really hope this breakdown has given you the hard data you need to start asking the right questions.